with another exciting video. This gentleman is not wheelchair bound. The defendant, actually, the victim in this case is no longer among the living. It started off where the victim was on the way to bring the niece of the assailant the $10 that he owed her, but he came into the neighborhood driving at excessive speed. And you all often see in some neighborhoods where they put signs out: children at play, slow down. So the assailant actually told the victim, "There's children out here. You need to slow down." So I guess the guy didn't take it too kindly that he was chastised of his own actions. Sometimes people just need to say, "Okay, right, I'm in the wrong. Let me correct my ways." But some people don't do that. Some people, what they do is they are the big bad wolf, and you're going to listen to what I say because I know I'm wrong, but you're going to listen to me. So once the guy paid the $10 back to the niece, he left and came back. Alleged he kept motioning that he possibly had a weapon in his pants. And when he approached the assailant, the gentleman that's not wheelchair bound, he actually was the one that was victimized because he was shot. So the niece says she ran over and stopped protecting the gentleman, trying to, do aid to the gentleman, talk to him, keep him alert. And the actual assailant, which is the uncle of the niece who did this alleged crime, drove off. How did he get in this wheelchair? I'm not sure, but he's definitely in a wheelchair, and he's a repeated offender. This is a long case. I'm dropping 3 long cases tomorrow, and this is going to be one of them. So let's dive into the content, and we'll be back.
Okay. Carintha James Bush, calling case 2457756. People of the state of Michigan versus Carintha James Bush. Defendant is charged in count 1 homicide, murder, second degree. Count 2 weapons, firearms, possession by a prohibited person. Count 3 and 4 felony firearm. Defendant has a habitual offender, fourth offense, notice, mandatory 25-year sentence. Appearances for the record.
Good morning, Your Honor. John Bell on behalf of the people, P68673.
Good morning, Your Honor. May it please the court, Berkeley Johnson, appearing on behalf of Carintha Bush, P46646.
All right. Your name for the record.
Carintha James Bush.
Date, time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
How many witnesses will be?
Can you call 2 witnesses?
Any preliminary matters before you call your witnesses?
Your Honor, if I may approach, there's a stipulation to the only exhibit I'm going to use, People's Exhibit Number 1, which is a postmortem report victim in this case, Christopher Watson.
Okay.
May I approach?
Yes, so stipulate for purposes of preliminary exam.
The court receives that stipulation and will admit the exhibit. Okay. Thank you, sir.
Your Honor, we have one more just minor stipulation. It's for preliminary exam purposes only. That is relative to count 2. The defendant had been previously convicted of carrying a concealed weapon, specified felony. He has not regained eligibility to possess a firearm, and that stipulation is for exam purposes only.
So stipulated for purposes of that stipulation. If I hadn't said it already, folks out there in YouTube land, if you're a witness or potential witness, I'm going to log off this time. Do we have an exception for OIC agreement?
I would ask the OIC be allowed to remain. She's seated next to me in the courtroom.
No objection. Okay. All right. Sorry.
Thank you, Your Honor. Call to the stand, Danielle Logan.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat. The witness box next to me. Voice up nice and loud. Speak to that microphone with the light on it. Yeah. And begin when you're ready.
Thank you. Good morning, Ms. Logan. Can I ask that you state your full name and spell it for the record, please?
Danielle, Donielle, Logan, Logan.
Thank you, Ms. Logan. Ms. Logan, I want to get right to the point. Do you know an individual by the name of Corintha James Bush?
Yes,
And how do you know Corintha James Bush?
he's my uncle.
Your uncle? The person you know is Corintha James Bush. Do you see him in the courtroom today?
Yes,
Can you point to him, identify what he's wearing?
a green outfit, and a mask.
Thank you. Your Honor, may the record reflect the witnesses identifying the defendant, Corintha James Bush.
So noted.
Ms. Logan, I'm going to direct your attention to June 10th of 2024. Were you outside the location of 11676 Marlowe in the city of Detroit, the state of Michigan?
I was outside sometime during the day.
Okay. And what time during the day were you outside that location on June 11th? I'm sorry, June 10th of this year?
I was outside when the incident happened.
Okay.
Well, the first incident happened.
Okay. And I'm going to ask you about that. Let me just clarify. Was it daylight during the day?
Yes,
Okay. And at what is located at 1167 Marlowe?
that's where I reside. I live there.
Your home?
Yes,
And who do you live with?
I live with my uncle, my mom, and two of my aunts.
And who's your mother?
Guinevere,
And who are your aunts?
Rhea, Renita, and Renee.
Thank you. Now, you mentioned the first incident. Let me just ask you this. Do you know an individual, or did you know an individual by the name of Christopher Watson?
Yes,
And was Christopher Watson present outside of your home on June 10th, 2024?
yes,
When you refer to the first incident, was Mr. Watson involved in that first incident?
yes,
Was the defendant also involved in that first incident?
yes.
And can you explain to the court what type of contact Mr. Watson and the defendant had on June 10th?
It was no physical contact. My uncle Chris actually came to the house to see me. And as Chris was coming up, my uncle just said, you need to slow down, you drive too fast. And that's all he said. And Chris immediately just started yelling, nigga, what? Mind your business, mind your business, mind your business, nigga, what, nigga, what?
And Miss Logan, unfortunately, I can't ask you what Mr. Watson is saying, but let me ask you this. Did they exchange some words between Mr. Watson and the defendant?
No, my uncle said what he said, and then Chris just went off.
Okay.
I didn't hear my uncle say anything after that.
Okay. Why was Mr. Watson at your home on that day?
He owed me $10.
And did you know he was coming over on that day?
Yes,
And did he come over to give you the $10 he owed you?
yes,
Now, after there were words exchanged, did Mr. Watson leave the location?
yes,
Was he driving a vehicle?
no,
So he left on foot?
yes,
Now, a short time later, did you see Mr. Watson return to the area?
yes.
During this time, where was the defendant?
He was in his vehicle,
And what type of vehicle was that?
a white Expedition,
And he was just sitting in his vehicle?
yes.
Just to be clear, what seat was he sitting in?
The driver's seat facing towards Plymouth,
So he's sitting in the driver's seat of his Ford Expedition?
yes.
How long was he in his vehicle for?
I don't know, from the first incident, he was still sitting there until when Chris came back.
Do you know approximately how long that was?
No, maybe 5, 10 minutes, I don't know.
And when Mr. Watson came back, did he specifically go to the defendant's vehicle?
Yes, I was in the house, but my auntie said he pulled up.
And again, I can't ask you what somebody said, so that would be hearsay. But I understand you're just trying to answer my questions. Did you see him go to the defendant's vehicle?
Yes,
And what did, and I can't ask you what Mr. Watson said, what did Mr. Watson do when he arrived at the defendant's vehicle?
he was standing on the side of his, door, driver's door, holding his pants.
And when you say driver's side door of the defendant's vehicle,
Yes,
do you know if they were exchanging words?
I couldn't hear my uncle saying anything, but I heard Chris.
You say he was holding his pants. Can you stand up and show me how he was holding his pants?
He's holding his pants like this, and he was yelling at my uncle.
Turn around so I can see.
He was holding his pants, yelling at my uncle.
Okay, indicating for the record, she has both of her hands on the waistband of the front of her pants and moving it up and down.
Thank you, Your Honor. Ms. Logan, did you ever see Mr. Watson with a gun or any type of weapon that day?
I couldn't see, his back was to me.
Okay. So is it fair to say you never saw him with a weapon?
No, I did not see a weapon.
Okay. And did you ever see the defendant with a weapon that day?
No,
What happened as Mr. Watson was outside the defendant's vehicle?
he was holding his pants and he was yelling at my uncle. Yeah.
And I can't ask you what he was saying, but okay.
Yeah, he was just yelling at my uncle, and next thing I know, he was falling.
Did you hear any gunshots?
I didn't hear anything. I just heard Chris yelling. He was yelling.
So he's yelling, and then you saw Chris falling, Mr. Watson falling?
Yes.
Okay. After Mr. Watson fell, what did the defendant do?
I don't even know because I focused on Chris.
Did you go out to Chris?
Yes.
And did the defendant drive off?
I don't know. I don't remember what he did because I was focusing on him. My aunt was yelling and I was focusing on him.
Okay. And when you saw Chris fall, he was standing next to the defendant's vehicle?
Yes.
Which side of the vehicle?
The driver's side.
Okay. And when he fell, you went out to help him?
Yes.
Why did you go out to help him?
Because he fell.
When you say he fell, was it like a trip and fall, or did his body?
No, he just kind of like laid back, just, it was a slow motion. He just fell. That's all I know. He just slowly fell down. Wasn't like he fell hard or anything. He just fell down. I was actually on the porch, so I had to get down there too.
Okay. And when you got down to Chris or Mr. Watson, did you notice any injuries on him?
I just saw his shirt was you can see a little blood on his shirt.
Where at on his shirt?
Right here.
You're pointing to the left above your chest, between your chest and your shoulder blade?
Yeah, it looked like it was bleeding from his shoulder like area.
Okay. Was he responsive at that time?
Yes, he was, yes. My auntie was actually talking to him. And yes,
And did you try to assist Mr. Watson or help him?
my auntie was down there, I was calling 911.
And did the paramedics and police arrive?
Yes,
And did they take Mr. Watson to the hospital?
Yes,
And you were interviewed by the police, is that correct?
yes,
Do you recall being interviewed by the police on that day regarding this incident?
yes,
Recall telling the police that there was a gunshot was fired by your uncle?
no. I know a gun was shot, Chris was on the ground, shot. I didn't see him shoot him. I didn't hear him, I didn't hear a gunshot, I just saw Chris fall.
Okay.
All I could hear is Chris yelling, and like I said, he was yelling and then he fell. I didn't see nobody with a gun, I didn't see a gun. Chris back was to me, so couldn't even see my uncle because he was standing in the view of my uncle.
Okay. Was anybody else around that area at the time that Chris fell?
My auntie,
But no, around the area of your uncle's vehicle, there was no other people around other than Chris? Is that a yes?
no, no one was
No
around.
one was around, okay, thank you. Thank you, Ms. Logan. I don't have any further questions for you at this time. I believe the counsel will.
Cross-examine.
Good morning, Ms. Logan. I know this has been a stressful situation for you, and I know you had to talk to several police officers that day, correct?
Yes,
And it appeared to you that the police, though you had given a story to one officer, it appeared to you that all these officers wanted you to reiterate what you had told the first officer, correct?
yes,
So you may have said, left a fact out, or something may have came to you, but you talked to the police and you were trying to be honest and forthright with the police at that time, correct?
yes,
Okay. And then homicide came late, right? And that's when they asked you to give us the statement to the officer that evening, correct?
yes.
So that's the statement I'm gonna really focus on. So I'm gonna ask you some questions, and if you have a hard time recalling based on what you said, just say that. And if you don't understand the question, just tell me and I'll repeat it and try to make it more clear to you.
Yes.
You knew the victim prior to this incident, correct?
Yes,
And you didn't know of any bad blood between your brother, Mr. Bush, and the victim, Mr. Watson, right?
that's my uncle, no.
Yeah, I'm sorry. In fact, as you said, Mr. Watson came down to your house to see and talk to you on that day, correct?
Yes,
And you all were talking in the walkway leading up to the house just prior to the first incident, right?
yes,
And your brother who resides with you pulled up home to drop off a soda pop to you, correct?
he had already dropped the pop off.
Okay.
He was sitting there still.
But that's how he happened to be there.
Yes,
Yes, okay. And those are the kind of little intricate differences might be in my questions, so you can straighten those out. Feel free to. In fact, your brother pulled up and he parked on the opposite side of the street, correct?
yes,
Going in the opposite direction, correct?
yes,
So that means, just so the court will understand, if I'm headed this way, the street's a two-way street, Your house is on this side, right side where he's parked, right?
Yeah,
He was parked facing the wrong way, correct?
correct.
Which made his driver's door on the side of the house,
Correct.
right?
Yes.
And it made his passenger door towards the middle of the street, correct?
Yes.
Okay. And your brother suffers from some serious medical conditions, correct? In fact, your brother,
He's my uncle.
I'm sorry, I've been preparing this stuff and I've been doing it myself, I'm sorry. Your uncle, Mr. Bush, suffers from some extreme medical conditions, correct?
Yes.
And on this day in question, one of the conditions is, he has a very large swollen scrotum, correct?
Yes.
Almost the size of a cantaloupe.
Yes.
Okay. And so he has to walk. If he walks, he has to actually carry his scrotum, and he can only move very slowly, correct?
Judge, I'm going to object as to the relevance of this question.
Judge, I'm gonna tie the
Sounds like a little
relevancy.
bit too much information.
Yeah, I knew it was gonna engender that, but it's very important because it goes to our defense and his ability to act and react or run or, you know.
I'll give you a little.
Yeah, that's all I want, Judge. I just want the court to understand that because it's relevant. So when Mr. Bush parked on that side of the street, it helps him to get out of the car and go into the house much more easily, correct?
Yes.
Okay. And you've known sometime that he might have high or low blood pressure based on his cirrhosis, and that he can become dizzy or fall out and things of that sort, correct?
Yes.
And you all care for him and help him in those times, correct?
Yes.
Okay. And in fact, I'm just speeding ahead so we can get through this. When he left the scene after the shooting, no one knew where he went immediately, correct?
No.
And police were asking you, where could he be, were the relatives and things of that sort, and you all told them no, right?
Yes.
And at some point, Miss Renita, your aunt, right?
Yes.
She was trying to contact him by phone and he kept going to voicemail, correct?
Yes.
And then at some point, he contacted someone and told them he was at the hospital, correct?
I don't know.
I'm going to object as to your saying.
But you learned later that he had driven himself to the hospital, correct?
Yes.
Judge, again, I'm going to object as lack of foundation.
Judge,
For her knowledge of that.
just,
I have to sustain that objection.
okay. At some point, the police informed you that he was at the hospital and they went to see him there and interviewed him, correct?
Judge, again, I have to object. As to
I'll move on. So as your brother got out of his car, recall him getting out of his car when he originally came into the house? Your uncle?
Yes, he came in, he brought my auntie a pop.
You didn't hear what he said to Mr. Watson, did you?
Yes, he told Chris, that he should stop driving up and down the street fast.
Okay, so that you're characterizing the best of your memory on what he might have said.
Yes.
But it had something to do with him flying up and down the street every day, right?
Yes,
And he said that he almost hit it.
yes. he did.
I'm gonna object this.
Not
Well-
offered by a party at home.
Well, pardon, Judge.
Sustained.
At that point, when he made those statements, Mr. Watson went ballistic, right?
Oh, yeah.
Okay. And when I say ballistic, he lost control, started yelling obscenities, cursing, as you indicated, using fighting words and things of that sort, correct?
Judge, I have to object this.
Judge, I'm laying a foundation
Conclusion
because
based on hearsay.
I'm laying a foundation because there's gonna be a lot of excited utterances coming in. So I'm laying the foundation for that.
Lay a foundation.
Yes. So when he started hollering, that raised the temperature right then at that point, correct?
Yes,
He was excited, your brother was there, you were there, you started trying to calm him down, correct?
yes,
You agreed that at that time, there was an atmosphere of excitement.
yes,
Yes, and that's when Chris or Mr. Watson started yelling all these obscenities, correct? These utterances came out of his mouth during that excitement, correct?
yes,
And he started using fighting words, correct? Obscenities.
I'm
yes.
gonna object, calls for hearsay.
Judge, that is not hearsay. Those are not the words spoken, and they can come in. If I ask those words, they can come in as excited utterances.
You have to lay a foundation for it.
That's what I was trying to lay down foundation, that they happened at or near the time of the excitement. She
So you
indicated,
have to ask her questions about her familiarity with the plaintiff witness. Have you seen, or how would you describe?
I was gonna do that.
Just kind of put the cart before the horse.
Have you never seen Mr. Watson act that way, correct? You told the police that, didn't you?
Yes,
You told the police that you've known him for some time, but you've never seen him lose control like that.
no,
And you tried to calm him down,
yes.
but you couldn't calm him down.
How would you describe his demeanor?
He was irate. It seems like,
What makes you say he was irate?
I never seen him yell like that. Yell, scream, his mouth was tripping. It looks like he was just at his boiling point, you know, and it took me by surprise because I had never saw him like that.
Did it appear he snapped in a kind of a way?
Yes, it's like he changed in front of my face, like changed into this monster. I mean, I had never saw him like that, and he just, you know, it was frightening.
And your Renita, she came out, right? Your aunt,
Yes,
because she heard him screaming and howling, correct?
yes,
And she tried to assist you in calming him down.
yes,
And it just got more excited and at that moment, and he became even more irate, correct?
yes,
Now, you tried to calm him down and direct and tell him to direct this conversation to you
yes,
and not your brother or anyone else, correct?
yes,
At the same time, Renita was trying to do the same thing and get him to move away from in front of the house going back towards his house, correct?
yes,
All during this time, this excitement and stressful situation was taking place, correct?
yes,
And at some point, you even felt as though you all might be in danger or he might strike out at you, correct?
Yes, and we stepped back at that point.
And you and Renita discussed that even after he left, how that created some fear in you, correct?
Yes, my auntie said this is not over.
Judge, I have to object, that's what you're saying.
That would be hearsay, sustain.
Well, if she said it, okay, but Judge, I suggest if she said it at the time of the incident during the excitement,
But
she just uttered it.
Went from the complaining witness being excited and what he said hasn't laid a foundation for her being excited as to what she said. So it's an out of court statement.
Okay.
For the truth of the matter asserted.
No problem. Did you honestly believe that you, your brother, or your uncle, or Renita?
Uncle. I made this just for you.
Hey, Judge, I've been doing this all day. As I prepared my cross-examination last night and this morning, I kept having to remind myself, I'm sorry. I'm gonna just say Mr. Bush. Okay. So, let's see, where was I? Did you honestly believe at that moment, ma'am, that you, Renita, or your brother may be in danger? I'm just talking about your honest belief.
I was scared.
Okay, just good. Would you say his shouting and the words he was using, he used them in an aggressive manner?
Yes.
Were they offensive?
Yes.
In fact, you couldn't remember all the words he used when you talked to the police, correct?
No, everything was just going so fast. It was crazy.
But he appeared to be in a rage, correct?
Oh, yes.
In fact, okay. And this all arose out of the one statement that your brother made to him.
Yeah.
Your uncle made to him.
Yes.
Okay. I'm breaking the
I gotta
record.
put it on mark my pins now.
I'm breaking the record. I'm breaking the record here, Judge. During that time, you never heard your brother, your uncle, respond. I wrote that down. You never heard Mr. Bush respond to Mr. Watson with one word.
No.
You never saw him retaliate or anything of that sort.
No. I was focused on Chris.
You saw Mr. Bush remove himself from that situation and go either in the house or to his car.
He got in his car.
Okay. You all continued to try to calm him down and walk him down the street towards his house.
Yes.
As Mr. Bush was going to his car, you admonished him, right? Addressing him about what he had said to Mr. Watson, right? You kind of.
I told him he should mind his own business. Stop saying stuff to people. You can't say stuff to people all the time.
Mr. Bush didn't argue with you. He just took it.
He got in his car.
So you eventually went in the house, kind of thinking that you would put the fire out a little bit, right?
Yes,
Um, At that time, when the police questioned you about a firearm, you told them that you didn't know Mr. Bush to carry a gun, right?
yes,
And you had an opportunity to observe Mr. Bush on that day at that time, right?
yes.
And he didn't appear to be carrying a gun on his person when he left out the house to get in his car, right?
No, because he always told me this, you know.
Yeah. Yeah,
Okay.
as I described earlier.
Yes.
So you didn't see him when he drove back up. That's what you learned earlier, but you saw him at some point, right?
I just saw the car when it pulled up.
Okay, all right. So when you saw the car pull up, you saw it stop in the middle of the street, right?
Yes, on the side of my uncle's truck.
On the side of your uncle's truck,
Yes,
right? And you knew that was strange, correct?
yes,
And you saw him jump out the vehicle and he left his car door open, correct?
I didn't see him jump out the vehicle. I saw him when he was in front of the vehicle.
Okay, so at the point that you came to the door, you were standing in the doorway or on the porch, correct?
I was standing in the doorway, and by the time I was standing in the doorway, Chris was standing in front of, he was coming around, my uncle's truck.
Okay, and again, it appeared to you that he was still out of control and had not cooled off, right?
Yes, he was yelling.
And he was yelling the same kind of words and things of that sort,
Yes, yes,
in a threatening gesture and making threatening gestures.
yes,
Okay, and those threatening gestures were, as you characterized to the court, the pulling of the pants
he was
Or-
holding his pants and nigga, now what, now what?
in the waist area.
Yes,
Okay. And you didn't know what he was doing at that time, correct?
no, I just knew, I knew he was there, but he was very aggressive talking to my uncle. But I thought he was getting ready to jump off.
Okay. So at that point, you had an honest belief that that Mr. Bush safety may be in jeopardy, right?
Yes, I thought he was in danger, yes.
And before he returned and left, it was clear to you Mr. Watson had went away angry.
Yes,
You had tried to reason with him, but he kept yelling and being out of control, and that's the way he left. Now, you also knew that Mr. Watson had a habit of driving, speeding up and down the street.
Yes,
And at the time that you saw him verbally attacking your uncle at his car window, is that correct?
Yeah.
He did that in an aggressive way.
yes,
And you knew from Mr. Bush's health and medical condition that he couldn't fight or defend himself, correct?
absolutely not.
He could not run, get out the car and run for his safety, correct?
No,
He did not say one word or make any aggressive gestures towards Mr. Watson that you observed.
no,
He did not respond to Mr. Watson's actions in any way that you observed.
no,
When Mr. Watson returned with his vehicle in the manner that he did he surprise you?
yes,
And at that moment, your brother was peaceably sitting in his vehicle.
yes,
And this was all happening quick in a matter of seconds, correct?
yes,
You couldn't see Mr. Watson's face because his back was to you, correct?
yes,
And you couldn't see Mr. Bush's face because Mr. Watson was blocking,
my view from my uncle,
and your uncle's window was down.
yes,
And at that point, you couldn't see if Mr. Bush shot him or how he shot him or anything of that sort.
no, no,
But did you say you heard the gunshot?
I don't recall hearing it.
Okay, I just wanted to make
Chris,
sure. Yeah. Um, but what you did see, you kind of put everything together, right? In other words, you saw him run around to your brother's, to your uncle's car door, right?
yes,
And at the same time, you saw the yelling, you heard the yelling and all that. And then you saw him fall.
yes,
And in your mind, you had an honest and reasonable belief that Mr. Bush may have shot him or something.
yes,
Okay. And that was based on your whole honest belief of what you had observed from all the facts, correct?
yes,
You never told Homicide he was known to carry a firearm, correct? You,
Who was known to carry a firearm?
Mr. Bush.
Oh, no.
Nothing further, thank you.
Any redirect?
Just briefly. Ms. Logan, I just want to clarify, because we went through the different kind of incidents that you described it. The first time in this argument between the victim and the defendant, you never saw Mr. Watson with a gun or any weapon, correct?
No,
And the second time when he came back, you never saw him with a gun or any weapon, correct?
no, I just saw him holding his hands.
Okay, and when you were helping Mr. Watson after he was laying in the street bleeding, you never saw any guns or weapons nearby, correct?
No,
Okay. Now, defense counsel asked you questions specifically about knowing whether the defendant carried a gun. Did you ever look in his SUV to see if he had any guns?
in my uncle's truck?
Yes.
No, he wasn't there.
Prior to the shoot,
Oh, no,
you never looked in his vehicle or looked for guns, correct?
no.
And at the location of 1167 Marlowe Street in Detroit, who in that home owned guns?
I do.
Okay, what kind of guns did you own?
I have a 380.
I'm gonna object to the relevance, Judge, lack of foundation.
Foundation, I'm asking her, the relevance is there were multiple guns and different ammunition taken from the home, so I'm just trying to clarify.
I'll move on.
And you had it was a Versa 380, correct?
Pardon me?
A Versa 380 handgun?
Yes,
Did you own any other guns?
no,
Are you aware of anybody else in the home owning guns other than your handgun?
no,
And was the defendant living with you at that time on June 10th?
yes,
And which bedroom was his?
the upstairs bedroom.
Judge, I'm object to the relevance and it goes beyond the scope of direct and cross.
He asked specifically about whether the defendant was known to have a gun.
And then that was based on, okay.
And Miss Logan, I'm sorry, which bedroom was the defendant's?
Upstairs bedroom.
How many bedrooms are there upstairs?
It's 2.5.
Upstairs?
Yes,
And if you can describe which bedroom was the defendant's?
to the right.
So if you go up the stairs to the right,
Yes,
which direction, do you know, cardinal direction that would be?
to the, I don't know, to the right. You go upstairs, when you walk up the stairs, it's a room straight ahead, and then it's one to the right.
Whose
And then
room,
it's a half a room, a little over.
whose room is straight ahead?
My mom.
Does your mom own any guns?
No, not that I know. I just know what I own.
Thank you. I don't have any further questions.
All right, thank you, ma'am. You may step. Any other witnesses?
Your Honor, I'm gonna call, Renita Bush.
Good afternoon, ma'am. Please step forward, give your name and the spelling of your name to the young lady seated here. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat. The witness box right next to me. Place up nice and loud and speak into that microphone that'll be to your left once you have a seat. One with the white one. Ready when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Bush. Can I ask that you state your full name and spell it for the record?
Renee Bush, RHEANITA.
Thank you, Ms. Bush. Ms. Bush, I understand you don't want to be here, but I have to ask you some questions relative to June 10th of 2024. Where were you living on June 10th, 2024?
United States, Street, Detroit, Michigan, 4226.
Thank you. Do you know an individual by the name of Corintha James Bush?
Yes,
What's your relationship to Mr. Bush?
sister.
You're his sister. Unfortunately, I do have to ask you, Ms. Bush, can you just point to the individual, if you see him in the courtroom, that you know as Corintha Bush, your brother?
Point to him.
Point to him and identify him. Thank you. Your Honor, may the record reflect the witnesses identifying the defendant, Corintha James Bush.
So noted.
Ms. Bush, I'm going to get right to the details here. On June 10th, 2024, was there a shooting outside your home?
Yes,
Did you witness the shooting?
yes,
And did you see the defendant shoot a gun? And was he in his vehicle parked outside your home when he shot his gun?
yes,
Did you see the individual that he shot?
yes.
Was that person Christopher Watson? Okay. Now, Ms. Bush, as it pertains to Mr. Watson, after he was shot, did you try and help him? Or Chris, as you know?
Yes,
Did you ever see any guns or weapons on Chris's person or around Chris? After your brother shot Chris, did your brother drive off?
yes,
Thank you, Ms. Bush. That's all the questions I have.
Cross
I believe the defense counsel will have questions.
Good morning, Ms. Bush.
Good afternoon.
You didn't know of any bad blood between your brother, Mr. Bush, and Mr. Watson, correct?
no,
And you didn't have a relationship yourself with Mr. Watson, correct? Other than seeing him up and down the street as a neighbor. And you also knew Mr. Watson to speed up and down the street habitually, correct?
me personally, I never seen.
Okay. Now, I want to address your first answer to the prosecutor's question of whether you saw the shooting. You gave a number of statements to the police at the time they were investigating after the shooting, correct?
Yes.
And, you know, you had police officers asking you to restate the facts on several occasions, correct? Then also you end up talking to homicide, correct?
Yes.
But one thing was consistent. You told the police that you never saw him actually shoot Mr. Watson, correct? You heard the gunshot.
I seen Chris pull up on the side of my brother. And he was pulling on his door. That made me go on the front porch. And I'm just standing there and couldn't get the passenger door open. So he goes around and driving on the driver's side. And he was just saying like, "Nigga, what did what?" And I'm standing there and I just saw a flash.
Now,
And then-
Miss Bush, at no point in time did you tell any police officer in any of your statements that you saw a flash, correct? Now, we can go through it all and I can even put the tape on, so I'm asking you to try to give your best answer. You never
I saw
told,
a
wait a minute, we
flash
both
or a
can't
spark.
talk at the
Okay.
same time. You never told the police, not one, that you saw a flash. Am I correct?
What did I say, a spark? I thought-
No, you didn't say a flash or a spark. You said you didn't, I'm sorry. You said you didn't see the shots, and I can show you your statement if you want to see it. You
I
didn't,
said.
wait a minute, we can't talk at the same time. And I'm not trying to argue with you. I'm just trying to clarify and refresh your memory if I can help you. Just want you to take your time and answer the question truthfully. You never told the police, and this is specific, that you saw a flash, correct? You told them you heard a shot and saw him fall. Is that correct?
No, it's not.
Here we approach. based on our sidebar judge. So at some point you saw your niece, Danielle, outside, you heard her outside trying to cool off Mr. Watson, correct, at some point?
Yes.
And you heard Mr. Watson hollering, cursing, verbally threatening your brother prior to the shooting, correct?
I mean, is it all right if I speak what happened?
That's what
Ma'am,
we
all
want
I'm
you to tell
asking you,
That's what we want you to tell us, what you heard.
Okay. So I saw my niece talking to Chris and trying to calm him down, and that's what made me go outside. When I get outside, I'm like, what is going on? And I heard my brother say, man, all I was trying to tell you, you need to slow down because you be speeding down the street and you almost ran into me. And he was like, nigga what, fuck you, nigga what? And that's the same thing I said to Team. He said this lady Team about 4 or 5 times. So I walked up to him and said, Chris, I said, what's going on? Talk to me. And I hear him by his right here, and I said, calm down, please calm down.
okay, just at that point, ma'am, I don't want you to keep narrating, but I'm gonna ask you some questions from that point. You both were trying to get him to calm down and he didn't calm down, is that correct?
No, he
And, you all tried to get him to leave and walk away and go towards his house, is that correct?
no, he was already walking towards his house.
Okay, so at some point he walked towards his house, correct? And you and your niece had some discussions, and based on his conduct and aggressiveness, he even placed you all in some fear at that moment, correct?
So when I held his right hand, I said, Chris, please calm down, talk to me, calm down. And he like pulled his hand away from me and he said, calm down. His face was turned into a beast and he was like, calm down. What? I was like, oh, Lord.
Did it place you in fear, ma'am?
You tell me to back away because he was angry. And you could see it in his face. He was upset. He was very angry.
My question is, did he place you in any fear at that time for you and your niece?
Was I in fear? No.
Didn't you tell the police that you at some point felt like he might strike out at you and your niece? And you had that conversation with
I
your
mean,
niece?
if
Yes or no, ma'am?
could you repeat that?
Didn't you have a discussion with your niece that based on his aggressiveness, his yelling and his conduct, that at some moment during that time, he put you in fear that he might strike out at you or your niece, and that you didn't think this was going to end well? Yes or no?
Yes.
You never saw your brother not once respond to Mr. Watson's aggressive behavior.
No, I just heard him say that one thing. He needed to slow down.
He never engaged Mr. Watson at any other time, correct?
No.
In fact, he removed himself from the area and went to the house, or finally came out and got in his car, right? Where he sat, your brother.
Say that?
Your brother went in the house and came out and got in his car as if he was getting ready to leave at some point, right?
But I don't recall it.
Well, you recall, you told the police you,
Yeah. I
okay.
remember being there. He was, I had always seen him sitting in the computer.
Okay, you told the police that you saw him go get in his car, he had his keys in his hands at some point,
Okay,
and he was getting ready, as though he was getting ready to leave, correct?
okay,
And the last time you saw your brother, he was sitting in his car, correct?
yes, he was.
Peaceably sitting in his car, right?
Say yes.
And as you were in your doorway or on your porch, you made some observations, correct?
I was in a house.
Just let me go through these questions, Dan, okay? So what you observed was you saw Watson drive up in his vehicle, right?
Yes, I seen him pull up on the side.
And he stopped in the middle of the street, right?
Yes, and he stopped on the side of my brother's.
And right next to your Mr. Bush's vehicle, right?
Yes, he did.
And you know Mr. Bush was parked on the opposite side of the street in the opposite direction, correct?
Yes.
And you also know that he has a very serious and extreme physical condition, right?
Yes,
And without going further, I've made the court aware of that. You knew that by parking like that, it makes it easier for him to get out of the car and make his way up to the house, correct?
yes,
But you knew there was a problem when you saw Mr. Watson reappear in 5 or 6 minutes from the time he left. You knew there was a problem by the way he pulled up next to your brother's car and jumped out trying to open up the passenger door, right?
yes,
And you saw him pull to try to get in on the passenger door, correct?
yes,
And the door appeared to be locked, right?
yes,
He couldn't get in. And then you saw him aggressively come around the vehicle to the driver's side, correct? And you heard him aggressively yell and confront your brother at the driver's side of the vehicle where he was seated, right?
yes,
You told the police he rushed around the car so fast your brother could not pull off because of the way Watson pulled up on him, right? You recall that? If you don't, that's okay. I don't expect you to remember everything you told the police that day. You heard Mr. Watson yelling and cursing, using fighting words at Mr. Bush at his window, right?
yes.
As he tried to appear to.
So, Mr. Johnson, we can't read the report into the record. We have to get the testimony.
No, but these are my questions. I'm not reading from the report, Judge.
Sounds like you read.
No, well, I'm not. These are my words, my questions. I'm just reading to make sure I get it correct. Okay, at any point, it was during this encounter that you heard the yelling, the cursing, the attacking of verbally attacking of Mr. Bush, that you heard a gunshot Or you heard the gunshot, correct?
First of all,
Miss, could you answer the question?
no, I did not hear no gunshot.
Okay. And as you were talking to the police in homicide, you indicated he ran up to Mr. Bush, right? And while he was aggressively yelling, he was pulling and making motions around his waist, correct? Can you stand up and show the judge what you showed the police when you indicated he was?
First of all, did you say that he was doing something around his waist?
You made,
Yeah, well, when he's in around the truck, he was holding his pants up, you know, with his right hand, he was holding his pants up.
did you not motion to the police? Look at me, ma'am, please. Did you not show the police when you explained to them what he was doing? You did this movement around your waist?
Around my waist?
Yeah.
No, I don't recall.
Okay.
I don't recall.
Do you recall indicating he made any motions around his waist area?
All I know, he was holding up his pants on his right side, he was holding up his pants.
Did Mr. Watson's actions towards your brother make you fearful for his safety?
Yes,
Why?
because the way he was acting and the way he was trying to get to my brother. And I'm standing here and I'm looking and I just could not move. And I saw a spark or a flash, and then I saw Chris going down, and I'm like, did that boy just shoot him? And that's when I went down there to try to help Chris off, and my brother pulled off.
So at that time, during that time, you felt fear for your brother's safety?
Yeah.
And was your fear based on your honest belief at that time, based on all the circumstances that you had observed?
Yes.
You knew that your brother couldn't run, right? You knew your brother couldn't escape from that car, right? Based on his physical and medical condition.
Yes.
And did you honestly believe he could have been hurt, injured, or maybe even killed?
Judge, I have to object as to the relevance of this question. What's in the mind of this witness is not relevant to self-defense claim.
Sustained.
relevant. It's not.
I sustain the objection, Mr. Johnson.
Nothing further, Judge.
Any redirect?
Ms. Bush, I just have a brief follow-up. Defense counsel asked you about threatening statements, fighting statements, aggressive statements. Did you ever hear Chris threaten Mr. Bush?
I kept hearing him say, nigga, what, what's up, nigga, what's up? That's the same thing I was telling Tina. I don't know.
Other than that, did you hear Chris say anything else?
No,
Thank you. No further questions.
How old is your brother?
60, what, 22?
62 and 63. At the time of this incident, was your brother in a wheelchair?
No.
But he does have some significant medical issues that you're aware of, is that right?
Yes.
Any questions based on my question?
No, Your Honor.
Yeah. How big is Chris compared to your brother?
I have the medical examiner's record.
Judge, I don't believe that is necessarily accurate. We looked at that closely, so and
You
then
think her testimony is going to be more accurate than the medical examiner who did the autopsy?
Judge, I'm just telling you what I've watched video. I watched the police one officer out there compared himself to the gentleman to his size, and he's way bigger. So I'm just asking her what she saw. That's all, Judge, for the record. At that time, was Mr. Watson a bigger man than your brother?
Yes,
Was he heavier than your brother?
yes.
Thank you.
Thank you, ma'am. You may say that. Any other witnesses for the people?
Judge, I don't think it's necessary to call any other witnesses.
Any witnesses for the
No, Your Honor.
people?
Your Honor, I move for bind over as charged. I think the statement from the witnesses are pretty clear. There was an argument between the defendant and the victim in this case. It started after the defendant told him to stop driving so fast. It possibly may have said he almost hit him. The testimony is that the victim in this case got irate, made some statements to the defendant, and then left the situation, came back to the situation. There's testimony from Ms. Bush, the victim tried to open the door, the doors were locked, went around. I'm going to repeat, but she testified as to what the victim said, and the defendant shot him. An unarmed man, and in this case, obviously, it appears as though the defendant's going to try and argue self-defense, but there's no evidence of self-defense now. That would be a question of fact for the jury to decide. The victim in this case was unarmed and was shot by the defendant while he was seated in his vehicle. He certainly could have drove off or, rolled up the window or ignored him, but instead chose to shoot him and then drive off. So I am moving the bind over on all counts.
Mr. Johnson.
Judge, I'm well aware that this is a serious offense. I think I was charged with homicide in the second degree, but based on the testimony of the witnesses, which I believe to be credible, I would just indicate to make some legal arguments, Judge. I would indicate that at preliminary examination, the district court must conclude, and I know this court is well aware of the law, but for the record, must consider the weight and competency of the evidence and the credibility of the witnesses and evidence in the defense. People v. Yost 468-122, 2003. See also People v. Anderson 501-175, 2018. When the defense is complete and there are no conflicting facts regarding the defense, it could be argued that there was no probable cause to believe that a crime had been committed. People v. Redding, 290 Mishap, 65, 2010, citing People v. Walton, Nen, 272 Mishap, 678, 2006. However, the district court cannot refuse to bind the defendant over for trial if the evidence conflicts or raises reasonable doubt regarding the defendant's guilt, because this presents an issue for the trier of fact. Judge, I believe in this case, yeah, we have a self-defense claim, but I don't think there's any conflicting, I don't believe there's any conflicting evidence between the witnesses, what they saw, what they heard, what they felt, their honest belief, the fear. You know, the law says that you can use deadly or even non-deadly or deadly force if you have an honest belief that you may be injured, sustain great bodily harm, or even be killed. And you have to look at whether that belief is reasonable. His medical condition kind of, his vulnerabilities kind of heightened that issue, because in his mind, he can't escape, he can't run. This guy removed himself from the situation, he never responded. The fact that he simply told someone to quit speeding up and down the street, who has a habit of doing that, the testimony shows, everything kind of lines up. It lines up that he parked on one side of the street because of his mental infirmities and medical condition to get out, to make it easier to get into the house. It lines up that this guy is yelling, out of control. They can't control. He places fear even in Mrs. Danielle. She honestly said that she was even in fear. He was out of control. Never seen him act this way. Says his face turned into a beast from Miss Redding, Miss Bush. So these are circumstances, when you look at the totality of the circumstances, how it arose. He's sitting in his vehicle peaceably. He retreats to his vehicle. This guy goes home yet and has not cooled off. We get that from the testimony. Comes back within 5 minutes and he's making gestures as though he could be armed. My client is sitting in the vehicle. He's a smaller man. He knows he can't get away from him. He knows he can't run. He knows this guy's standing over him, and he shoots him. There's no established intent to kill other than firing to protect himself. And so I don't believe that second-degree murder is the appropriate charge here. I believe self-defense is a real defense here, Judge, and it may be a quantum leap that this court is not willing to take. But at the same time, there's even a charge that where it involves manslaughter, where a person causes the death, dies as a result of that cause of death.
You're better off arguing self-defense. Manslaughter does not apply here.
Well, it's not a manslaughter case, Judge. It's just where a person intentionally aims a firearm at somebody and shoots them without the intent to kill. You know, but we don't have to go there. I believe, Judge, based on my arguments, that self-defense does apply here, and clearly there's no second-degree murder on the part of my client.
Your Honor, if I may respond. Just briefly, first, self-defense, and everything defense attorney argued that the defendant had an honest and reasonable belief that the victim in this case was either going to cause him great bodily harm and or death. It can't be considered because there's been no evidence in this court as to what was in this defendant's mind, whether he thought the defendant had a gun or whether he thought he was in fear of great bodily harm and or death. There's none of that.
The standard is a reasonable person.
Well, I understand, but it has to be a reasonable person in the defendant's situation. And the only evidence we have here is that the victim was, I'm not going to repeat the words, but saying some words, holding, the witnesses both said he was holding up his pants and that there was no weapon visible, no weapon found. And certainly the court should bind this case over. And if he wants to argue self-defense, there has to be sufficient evidence as to the defendant's state of mind as well. And that should be left for a trier of fact.
See, the problem that you have here, and if this case gets bound over, you'll have over in circuit court, is that the only witnesses you can proffer lay the foundation for some kind of self-defense. There hasn't been anything contrary to that. Based on the testimony I've heard, we have the defendant who is 62 or 63 years old with all these medical conditions, who merely says to the complaining witness, slow down. You're driving too fast down the street, you almost hit me. And then the complaining witness, by your witness's testimony, goes ballistic to the point to where they can't control. He's walking over to the car. No, scratch that. I think I heard testimony that he left and then came back, pulled up alongside of him, gets out of his car, tries to get into the defendant's car, goes around to the driver's side of the door, telling him, what's up now? And at the time that he's doing this, he has both of his hands on his waistband and tugging at his pants. Now, one of your witnesses said that he was holding his pants up. The first witness said that he had both hands in front of his waistband and was pulling his pants back and forth. The question I have to consider is whether or not the defendant was reasonable in believing that he was in fear of death or great bodily harm. Now, the medical examiner's report says that the complaining witness is 36 years old, 5'9" and 140 pounds. Not a very big man, but I can't really see the defendant. The defendant was wheeled in here in a wheelchair, but he doesn't look, he looks like he's maybe 125, 130 pounds wet himself. I can't tell how tall he is, but from the way he's sitting there, he doesn't appear to be a very big man either. But the complaining witness is considerably younger than the defendant. The defendant is almost double his age. And both of your witnesses came forth and testified that they were in fear of the complaining witness. So if they're in fear of the complaining witness and his hostility and his anger wasn't directed at them, it was directed at the defendant, how must the defendant have felt at the time?
And Judge, I'm sorry.
Go ahead.
That's an issue where the court would have to speculate as to what the defendant is feeling. You know, the defendant's the one with the gun.
No, I'm only going by the evidence that you presented.
Well, I understand
you presented, like I say, lay the groundwork for self-defense.
But the court also has to consider other issues relative to self-defense, such as whether the defendant had an
One thing I have to consider is whether or not his fear of death or great bodily harm was reasonable.
Yes, and in determining whether that's reasonable, the court also has to consider whether he had to stay, whether he had means to leave the situation. He's in the driver's seat of his vehicle. He certainly could have just drove off. There's other considerations that the court has to make as opposed to, does he just get to shoot somebody because somebody's yelling outside his car, yelling at him, or for example, does he have to drive off?
But trying to get in and then saying, what's up now? What's up now? Which to me is threat. So I look to the case of People versus Shirt. It says the district court has the authority to consider defendants' defenses when determining whether to find over to certain courts. While affirmative defenses such as justification and self-defense must typically be presented at a trial, the inquiry at the preliminary exam is not limited to whether the prosecution has presented evidence on each element of the offense. Thus, if the defendant presents evidence that he or she has a complete defense to the charge on the undisputed evidence, it would be improper for the district court to bind over the defendant. So the undisputed evidence that I have is that the complaining witness was wilding out, confronted the defendant, and he was wilding out to the point to where this isn't lost on me either. Both of the witnesses that you called are related to the defendant. They're family. And I'm sure they don't want to see their uncle, their brother, sitting there in county greens. So perhaps their testimony may have been jaded just a bit. But I'm stuck within the four corners of this hearing and what they testified to.
Your Honor, no witness ever testified that they were in fear of great bodily harm and or death. They were afraid of what he might do, but there's.
Well, what might he do?
Well, even if it was a physical assault, even if the court were to make the jump that this defendant or reasonable person would be in fear of perhaps an assault, if he were to use non-deadly force.
This is where I put myself in the defendant's shoes. And I have to put myself in his shoes. This defendant is not Kenneth King sitting here, 200 pounds, 5'9", 54 years old. He's 62, 63 years old. I don't know how much he weighs, but they tell me that his testicles are the size of grapefruits. That he's sick. Each of the witnesses testified how ill he is. And this was on the day of the incident, although he wasn't in a wheelchair. On the day of the incident, he's in one now, but putting myself in his shoes then, not a well man being confronted by a 36-year-old who's considerably out of control.
I understand that, but I would imagine somebody in that situation would then just drive off. And that's what the court has to consider.
And Judge, the case,
none of the evidence here suggests that he was in fear of great bodily harm and or death. That's the complete different distinction of he didn't use non-deadly force here. He chose to shoot the victim. In order to use deadly force, which the defendant clearly did, he has to specifically be afraid of great bodily harm and or death, not just somebody challenging him to a fight. Even if he, thinks that's going to happen, he could have driven off. But there was no specific evidence that the defendant ever threatened to kill him, to do great bodily harm, and you cannot use deadly force against a non-deadly aggressor. Even if the victim in this case was going to cause him bodily harm, it has to be great bodily harm and or death, and I think that's why the court needs to find this case over, because none of that evidence exists.
Judge, I believe clearly the reason I raised the argument, because there is no evidence in dispute or conflict. Moreover, it's what the state of mind and reasonable belief was in Mr. Bush, and that can be shown by circumstantial evidence and the totality of the circumstances in which I believe this court has considered. And when you consider that, that's it. There is no other evidence that's been presented, Judge, to conflict with what we have. And that won't change whether it's here or there. So I believe the court can, based on People v. Hoskins, 403 Mishap, 95, 1978, use in this case to use circumstantial evidence in this case to establish that my client's state of mind caused him to act reasonably under those circumstances, and that he acted in self-defense. The reasonableness of his decision, Judge.
Just by virtue of the fact that we're having this discussion, probably lends itself to a question of fact to be determined by a trier of fact. But as the case indicates in People versus Shirt, I have the authority to consider the defendant's defense of self-defense. And if it is undisputed evidence that the defendant acted in self-defense, it would be improper for me to bind it over. I haven't heard anything contrary to what these witnesses testified to, that this younger man confronted this defendant, who is, again, sickly, much older. I'm just not comfortable in binding this matter over. As such, the court is going to dismiss for insufficient evidence.
Thank you. Just to be clear, first of all, for self-defense, the defendant must have honestly and reasonably believed he was in danger of being killed, seriously injured, or sexually assaulted. There's no evidence of that. Second, a person may not kill, seriously injure another person just to protect himself against what seems like relatively minor injury, which is the only thing the court here has here. And third, I don't know how the court's going to dismiss this case, because even if you were to decide that, we still have the felony firearms and the felon in possession charge and the CCW charge. Those have nothing to do with
You're correct in that. So the case, let me clear the record. The court is dismissing the homicide, murder, second degree charge, weapons, firearms, possession by a prohibited person. The court finds the people have met their burden of probable cause on that, as well as the accompanying felony firearm. Okay. But the homicide is dismissed for insufficient evidence. And how I arrive at that, to answer your question, counsel, this court can make, as you know, can make logical inferences based on the totality of the evidence. So based on the totality of the evidence, and this defendant being confronted again by a much younger man, and him being in the state that he's in, that I can infer based on the evidence and the witnesses that testified here, that if they were afraid, they were certainly him afraid of the same, and that he was the one who was being actually confronted. Okay, so count one is dismissed, as well as the count three, the firearm that accompanies count one. Court is binding over on count two and count four.
Thank you.
And thank you for that. I totally looked over that. I was only thinking about the homicide. I need dismissals as to counts 1 and 2. I'm sorry, 1 and 3.
Judge, can I address Vaughn?
Yes.
Okay. Judge, he's currently being treated at Henry Ford's. He's been in and out the infirmary constantly. He's on the transplant list. I'm very familiar with that because, as you know, I had a transplant in 2006. Transplant what? Liver. So I'm very familiar with that, very concerned with that. And he's not getting the treatment that he really needs at the jail. He can't eat. He just, like this week, he was just able to get a drink of water. Again, he's been in and out the infirmary. With respect to the change in the charges, he's on disability. I would ask the court, how long would you like? He's been locked up since June 10th. I would ask the court to consider a personal bond, Judge, because based on the charges that are left, I can attest to the fact we've had a good relationship, that he will appear. I will be representing him throughout this matter. And whatever his health status is, I will keep the courts informed and make sure he appears.
Well, I do have an issue with the fact that he allegedly had a weapon with him in the first place. It was not authorized to possess one. So even with that, the court would not be inclined to give a personal bond. How much do you think you could post that?
Judge, he doesn't know, but we'll take any nominal bond that this court consider. We trust your discretion, Judge.
Judge, I do believe a cash bond is appropriate, even on accounts the court's finding over one of the, as well as he's a habitual for one of the counts is certainly felony firearm, which is mandatory minimum of 2 years.
Judge, I probably will write a gun boy letter on that, but he's in
I'll set mine at $5,000 cash surety with the GPS tether.
no problem, Judge.
Absolutely no weapon, sir.
Thank you.
That's gonna make his arraignment date still gonna be August 8th, 2024 at 9:00 a.m.
Very much, Your Honor. Have a good day.
Thank you as well.
The bond reduction. Yeah. Yes, sir. Take it.
Okay, so thank you for tuning into this case. Like I told you, it was a long case, a lot of testimony, and it's sad that there were no winners in this case. All you were alleged chastised for speeding in a residential area. People do it all the time. If it's my child, I do not want to be receive a phone call that my child was hit because somebody was speeding in the neighborhood. Think about the video that's going around where the parents tried to revive their child. Well, he was hit by a truck and he was a grown man. This is a thing with a child with lesser reactionary time, what possibility would happen. There's no winners. The assailant is now in a wheelchair. Now he got to post some kind of cash bond. I guess the family going to have to sell some cash fish nuggets that come up with the bond, that cash bond, because when it's cash bond, if I'm not mistaken, you can put it in the comments, but I think it's dollar for dollar. If it's another type bond, I think it's percentage based, but if it's cash bond, they want all of the ching up front, right? But nonetheless, put it in the comments. How do you feel about this case? This is Antonio with Team Tiggio. Please like, comment, subscribe as we dropping heat on this channel. Like I said, again, tomorrow is going to be 3 long cases. And hopefully, like I said, that you like this case and, you keep us filled in. But nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe as we'll be coming to you more videos in the future.